So basically, once they are deaf, the process is rather simple. They just need to present a death certificate to the notary, or in this case, if they are doing it with a real estate agent, they can come to you, or they can come to a lawyer like me, or they can go straight to the notary.
Hi everyone, Taniel Champion here. I'm really excited about our upcoming interview with real estate attorney Orlando Santamaria. We've got a lot to talk about, so I think this is going to be a two-part podcast interview. We're going to cover how a real estate trust functions in the restricted zone in Mexico, the notary's participation, red flags to look out for, pitfalls, pre-construction contracts. There's a lot to cover, a lot of great information. I think you guys are going to love this. So enjoy the interview. It's going to be a two-parter. So let's start. Welcome to the Retirement in Mexico podcast, your guide to a life of sun, sand, and possibility. If you've ever dreamed of spending your golden years under the warm Mexican sun, surrounded by breathtaking beaches, rich culture, and an exciting community, you're in the right place. We're here to guide you every step of the way with expert insights, inspiring stories, and everything you need to know to make your move with confidence. The best chapter of your life is yours to create. Let's do this. Hi, Orlando. Thank you so much for joining us today for this podcast.
Thank you, Daniel. How are you?
I'm doing great. So let's start. You're an attorney in Puerto Vallarta, and your firm specializes in real estate, correct?
Yeah, that's correct.
Okay, so, I always tell my clients it's really important when you're getting involved in a real estate transaction to always hire an attorney to look at all these legal documents. Us as agents, we know a lot of the clauses in a contract, but the legal implications of it, we don't know the law inside and out like you do. So this is something that's really important for our clients. So I would like to start off by asking you, because most of your clients are foreigners, correct?
That is correct. Probably about 98% of our clients, 97% of our clients are foreigners.
So could you explain to us, because a lot of people don't understand how the real estate trust works in Puerto Vallarta. So could you explain to us what that is, how it functions and how it protects the foreigner who's buying real estate?
Sure. So the trust contract in Mexico, we actually I would say copy it from the U.S. law, from common law. And it works kind of the same way it works in the U.S. if people is used to a trust. If they are not used to a trust, it's very simple. The settler, in this case, the seller in a real estate transaction, transfer the property onto, to a bank, which in this case in Mexico are the only entities authorized to use to be trustees, okay? And then in the contract, the buyer is named as the beneficiary of that trust. So meaning that, and a very important thing on the trust contract is in a irrevocable trust. So that cannot be revoked by the seller. So at the moment the seller transfers the property onto the trust, the buyer becomes the beneficiary of that trust, and they can just, do whatever they want with the property. There is a set of clauses in that trust contract, and then usually the bank has a boilerplate, and in that boilerplate basically outlines the rights and obligations of the beneficiary of the trust, in this case of the buyer, which are quite simple. Just they pay a fee every year for the administration of that contract by the bank, not of the property, because a lot of people think they are administering the property. That's not. They administer the contract per se. That's why you pay them a fee to them.
Mm-hmm. Okay. So, does the foreigner have to have a trust regardless of where they buy in Mexico?
No. If they are buying what we call the restricted zone, which is 50 kilometers from the seashore inland or 100 kilometers from the borders inland, then they need a trust. So that is not an option for them. That is an obligation. Okay. If they buy outside of the restricted zone, for example, if they will buy in Mexico City, in Guadalajara, in Monterrey, like in one of the cities that are in central Mexico, or 60 kilometers up, away from our coast, or 110 kilometers away from our borders, then they can just buy it directly with direct domain. They still have the option to use the trust, like we Mexicans have an option to use the trust. But they are not obligated to. And that's also a misconception. When I tell people in my closings that some of my clients, Mexican clients, have properties in a trust, they said, Why? And I always tell them because the trust is a way, and the trust contract is a great contract to protect your asset, it's either for foreigners or for Mexicans.
So in the trust, so you have the buyer, usually let's say it's a couple, right? And they both have what, like 50%? Does it have to be 50% each, or they can designate different percentages?
Mostly it's 50%. Sometimes we have couples that they said, I want for this person 70 and this other person 30. So the most common and the most widely used is 50-50, but I have clients, they will use 70-30, 80-20, 60-40. And also I have clients who very smart, they put the names of all the family. Like if it's 4 members of the family, they put the 4 members of the family
as the primary beneficiaries.
Yes, they use as the primary beneficiaries, and that is very useful for capital gains. If we can talk about it later, because when they sell, if they are thinking in selling, that is a great way to.
All right, so you have let's say it's a couple, and they're the primary beneficiaries, and then they pass away. So what happens to the property?
If they both pass away, or one of them passes away.
Well, let's say one passes away.
If one passes away, it's very simple. In the contract, you state that in case of your death, the main beneficiary designates a beneficiary substitute. Usually people designate each other, but we'll take the example of a couple, right? 50 and 50. So that person designates the other party as the substitute beneficiary in case of their death. So basically, once they are dead, the process is rather simple. They just need to present a death certificate to the notary, or in this case, if they are doing it with a real estate agent, they can come to you, or they can come to a lawyer like me, or they can go straight to the notary. Okay. Mostly people will come to a lawyer like me because we explain it to them in English. We have English speaking staff, like things like that. So they want to know what's the process. And basically they have to bring the death certificate if they present to us. If the death occurs outside of Mexico, then there is an extra process. It's called an apostille on that death certificate. But if the death occur in Mexico, they only need the death certificate. And with that, we can get them to get the 100% owners of the property. So they have to transfer the 50% of the person that is dead to themselves.
Okay. And then when the surviving spouse or partner passes away, and then what happens?
Oh, well, so usually people, they have, like, for example, once, if they do decide, there's different scenarios. The scenario we were just talking about, if in that scenario, they usually have a second beneficiary substitute. Okay. And most of the time they designate, if they have children, their children. If they don't have children, they designate somebody of their families. So if the two of them are dead, then the person who is designated, or the persons who are designated as second beneficiary substitute, take place and will have the same process. Death certificates, and then the process it's actually very simple to me, and the way to I explain to my clients, why I explain to them, because in Mexico, a will can be easily contested. So I always recommend, if you have a property in the trust, do not put it in a will, because it's already very well protected with your trust.
Got it. Sometimes I've had clients where for the substitute beneficiary, like in the event they both pass away, they want to leave it to a charity. Mm-hmm. Is that something that's doable still?
Yep, it is doable still. The only situation is that I had in my practice is I had a case where they designate a charity in the U.S. Okay. For that, some of the banks will ask you the articles of incorporation or the document where that charity was created, just to make sure that it's just the document where it's created. Some charities or some organizations wouldn't provide that document. So therefore, some banks would say, no, you cannot put them as second beneficiary substitute. But in a strict sense of law, you can put them even without the document. You just can name it. And then if the two people die, then that non-profit organization will have to then get the property, which is also rather simple. They will need to have the document where they have the legal representative, which is the person who in turn can sign the document, the trust document. So the nonprofit can acquire the property in there. This is for a foreign nonprofit. For a Mexican nonprofit, it's even easier, because we just have to check the document in the nonprofit organization. The main thing is they actually able to receive donation. Okay. That is because some nonprofits are not able to, as weird as it sounds. So we have to really make sure that nonprofit is able to receive donations, because if you put them and they are not able to receive donation, then you will have a problem if those people die. Okay. Because they are not able to receive donation, then we have to make a process where, it's still doable, but it will take a longer time.
Yeah. I've had a couple of situations where my foreign clients who bought the property, it's in a trust, and we said, we need your substitute beneficiaries in the event of your passing. So who do you guys want to leave it to? They said, nobody. We don't have kids. We don't want to leave it to any of our relatives. No one. And so when that happens, who gets the property? Like, what happens to the property?
The bank gets very uneasy when that happens. Like, they don't like it. And even some banks, they said, no, we cannot create a trust like that. Most of them, they do, regardless. Like, if they both die or they that die. So that what happened is, in our law, there is a process that it states that because if you don't pay your trust for a certain time, after a certain time, then they can actually reclaim the property. And then in the case there are no beneficiary substitutes, they will just either give it to seller, and the money they are supposed to go to charities, to Mexican charities.
Okay. Wow. Interesting. All right. So let's talk about closing costs, right? So closing costs in Mexico is a little bit different than the States. So can you please explain what the closing costs are like here? And if there are any of those closing itemized expenses, they could apply that towards capital gains tax when they sell, or it just goes to the closing costs and that's it?
Okay, so the closing costs are way more expensive in Mexico than what you were used to in the US or Canada, just because this is the way I tell my clients, because your property taxes would be ridiculously cheap. So the government, of course, this is not true, but that's why I tell them, the government, you charge you in advance all the years. They want to make sure that you're going to live for like 4 years. I always made that joke, right? But basically the reason, it's because we have a couple taxes that are very, important in the transfer. And that's why they are way more expensive. The most important is the transfer tax. In Mexico, there is a transfer tax, and especially depending on the state where you're buying, that transfer tax changes. In Jalisco, for example, the transfer tax is calculated using the legal value of the property as per today. That might change, but as per today, they actually tried to change it a couple of years ago. And then for 1 year, we were in the limbo. And so some notaries were charging the transfer tax using the purchase price. Okay. So that's why, because other states like our neighbor state, Nayarit states that the transfer tax is charged using the purchase price, and actually their law says it's a 2% on the purchase price. It doesn't say the purchase price. It says whatever is higher between the legal value of the purchase price, but we know what is higher.
The market value is always higher.
Value is always higher. I think I've seen only one time that the market value was lower than the legal price. But yeah, 99.9% of the times, the market value it's higher, and that's how it's charged. And it's at 2%. So there you have a property, which is $1 million, for example. You're already paying 2% only in the transfer tax. Only the transfer tax. On top of that, there is the bank fees to create the trust. It's a property.
We talk about Nayarit, right? Right now, the 2%.
By Jalisco, I would say, so in Jalisco, it's not a percentage per se, because you have to put it in an index. And that index the government gives you that index in our Ley de Hacienda Municipal, which is, I don't know if you will translate that, but basically it's like the income tax law. And they put you on an index, and for an index, they give you like from 1 to 500, from 501 to 1 million, this is pesos. Okay. Mm-hmm. So based on that, where the legal value of that property is, you have to insert the value of the property there, and then you have to multiply it by another index, and then sum a base that they give you depending on the price. So it's a bit complicated, but the main point is that transfer tax, it's cheaper in Jalisco than it is in Nayarit. Yeah. Because it's always cheap.
Orlando, when you say a legal value, are you talking about the fiscal value?
The fiscal value, yeah.
The fiscal value. And that's what your property tax is based on, correct?
Yeah, that is correct.
Yeah.
So the lower that value is, the better for you, because that's how your property taxes will be calculated. And as you know, property taxes, like for example, sometimes for a property that is $1 million, they pay per year like $400,
yeah.
Which is nothing that they will pay back.
It's nothing. No, I have family in Los Angeles, and their annual property taxes, I think right now it's around $11,000. So,
sort of will be for a property here, maybe a hotel or something like that.
yeah, it's crazy. My property tax for this year, I think between $165, $170, $75, something like that for the whole year. And I paid in January. So I get that with a 15-20% discount that they give you. Yeah. I mean, I think property tax here in Mexico is pretty much a non-issue. You pay more going out for dinner than you would for your
property. That's what I tell my clients, you might be scared when you see the closing costs, because it will pay off because your property taxes will be very, very cheap.
Yeah.
Like close to
and the transfer tax, you can deduct that from capital gains tax when you sell.
So once you sell the property, you can use whatever the notary charge you for. They will give you a factura, an invoice, and then you can deduct that from the capital gains as well.
So how long does it normally take to close? So let's say I'm a foreigner, I'm an American, I go to Vallarta, I see a condo, it's a resale. The seller is a foreigner, is an American or Canadian. And so we come to an agreement, purchase sale agreement. So from that point on, how long can I expect to wait until I sign the deed and get the keys to the condo?
Depends. Depends which bank is holding your trust. So
the seller's trust.
The usual banks, like the ones we use them, like, can I say names, right? Banbajío, Monex, or Nifel, or Banorte, takes you like 1 month and a half. That's the usual time, 2 months. And more they're becoming faster. And so like sometimes we can close a transaction if buyer and seller say we want to close in a month and we have all the paperwork, like a line, then we can close really, really fast. But if it's a bank that is what I call bureaucratic bank, those ones, and those usually would take, with some, I would say HSBCs to us, working with them is the worst. If a trust is with HSBC, I always tell my client might take 9 to 10 months.
Well, I've had 2 closings with HSBC in the last few years, and they both took 9 months. And I've heard some banks it takes even longer. It could be a year and a half. So right now, would you say so could you go through like which are the best trust banks? And is that nationwide, or is that just in like Puerto Vallarta area that they work really well?
This is in Puerto Vallarta area also because I have worked with the same bank trust in different areas in Mexico. And I have to say it, we have the system here. We had a really, really well done because it's very fast and it's very efficient and it's very practical. The banks that we usually work with are, Banbajío, Monex, Banorte, and lately Nifel. We've been working also a lot with Nifel. And the 4 of them, they're really easy to work with and they're very fast to work.
Yeah. I mean, there's nothing wrong with banks like HSBC. You just need to know that some banks are slower than others. So when the buyer's agent's going to write up the purchase sale agreement and they see that the seller's trust bank is one of those banks that are slower, you just have to factor that into your estimated closing date. So don't put like a 60-day closing date. Chances are that's not going to happen. So maybe put
that offers like that.
What was that?
We have had offers like that, like HSBC bank with 2 months. And I'm like, you're kidding, right? There's no way we can close in 2 months. I can tell you right away. And I tell them, I said, if you want to look for another lawyer and if somebody can achieve that in 2 months, tell me, because I'm going to send them that kind of trust to them too.
Why are some banks quicker to close than others?
Bureaucracy, the level of bureaucracy. So banks like HSBC and Bancomer, because they are so huge and so big, they have their decision makers are not in town. So the decision makers are either in Mexico City or other cities around Mexico. So like just to send them paperwork, like a bank that is based here in Vallarta and they have a decision makers in Vallarta, you send them the paperwork, they review it, they said, okay, send the draft, and within 3 weeks they said, okay, the draft is approved. With a bank that they don't have a decision maker person in Vallarta, they have to send it to Mexico City, to Guadalajara, to other city, and just that email exchange might take 3 weeks, just the initial exchange. And after that, the review of paperwork, they even tell you, or review of paperwork might take from 20 to 25 days. So you already got 2 months there, and not always take 2 months. That review paperwork, it might take 4 or 5 months.
Yeah. So question. So let's say, I close, I have my deed, but I'm not happy with my trust bank. Can I switch to a different trust bank after I have my deed?
Yeah. you can, is actually outlining your contract in your trust contract. You can substitute your bank. You can change your bank at any time if you're not happy. If, as I said, most of the time people don't do it just because it will cost you money. It will cost them money. And, if it's a bank, then you just pay them a yearly fee to have that contract. So I say, what do you want to do it? Like, unless you're really, really bad, I suggest to change it. Or, for example, if you have a trust, if you have a home and your home is in a trust with one of those HSBC or one of those banks, I would say you can start the process of changing it now. So by the time you have a buyer, you probably, you initiate like 7 months ago, and now you will have the trust in somebody else's, in another bank. It will be much easier, the transaction.
Cool. So, and if the seller, let's say, is a Mexican national here in Puerto Vallarta, of course, so they don't have a trust. They don't need one. And here I am as the American coming in to buy. And I want to use, let's say, a bank like that. They have people that's staffed here in Puerto Vallarta. How long would it take for me to close? Let's say there's nothing wrong with the title. It's a clear title and I want to open up a new trust. So can we close a little bit sooner?
Yes, we have made closings of a new trust in 3 weeks.
Wow.
Yeah.
With a Mexican seller and a foreign buyer.
Yeah, because the agent representing the seller, the Mexican seller, had everything aligned because it was an agent who knew his job, and he had everything aligned. Like, he had everything up to date. And the buyer, the real estate from the buyer also, it was, like your agency, like they know, they have all the paperwork aligned. So it was just like, okay, they sent me the offer and I said, I need that paperwork. They sent it the next day and they sent the down payment from the closing cost day after. And yeah, we closed in 3 weeks, actually less than 3 weeks.
Wow.
Yeah.
Sounds like a world record.
It was very fast.
So do buyers and sellers have to show up to the closing?
No, actually, in a new trust, for example, the buyer does have to, the seller has to show up for the closing or sign a power of attorney to somebody to represent them in that sale. The buyer, however, and this is also something, it only happens in Vallarta because in other states, the bank won't allow you to use what we call an acceptance of the trust letter. So in that way, you sign a letter accepting the trust. We as the closing coordinators will create that letter. We'll explain you that letter over a Zoom call or a phone call. And then I'll just send you those documents. The client, the buyer will print them, sign them, and just FedEx back to us. And that's how we work.
Okay.
So if it's a new trust.
If it's a new trust.
Yeah.
So if I want to take over the seller's trust, do I have to be at the closing or can I also do a power of attorney?
You can do a power of attorney. So the other option for you is do a power of attorney.
Okay. And what if I'm getting a mortgage through a Mexican bank and I'm not able to come to the closing for whatever? I've got something going on. I live in the States. Can I give someone the PO8 and to go to sign?
So like, for example, if you are like, in this case, good thing that you brought that up. So if it's a new trust, but you are using a loan, they won't allow you the non-appearance letter. You have to either come in person or designate a power of attorney. Same thing, if it's a transfer of rights, you need to designate a power of attorney to accept that in your name.
Hey, can you explain what is transfer of rights?
Transfer of rights is, so you have a contract, a trust contract, you have a property in a trust. And so that contract gives you the trust rights on the property. Okay. So if you sell the property, you can use that same trust because the only asset of that trust is the property. Most of the time it's just some people have two properties which they bought in the same condominium or something, but 99% of the times it's just one property. The only asset is that property. The only liability is that property. So you transfer the rights of that trust onto the buyer, which is, again, is easier. And it's just, some people feel they have this, fear because again, they said, what are my liabilities? And I always tell them, well, the only liability is the property you're buying. So if there is something wrong with the property, that will be your own liability, nothing else. Like, you're not liable for anything else but the property.
Okay. So, Orlando, I got a question for you. This happened to me recently. I've got a client and, her parents, they're Americans. So her parents own a property here in Vallarta. Her father passed away. And so, the 50% that the father had to right to the trust is going to go to the mother. However, they haven't gone through that process, getting the death certificate and recognizing her mother as the sole primary beneficiary. And so the person who contacted me is the daughter. And the mother is, up there in age, is getting really fragile, and they want to sell the property. Their concern is they're thinking of the mother giving a POA to her daughter, who also happens to be the substitute beneficiary of that trust. But their worried is, what if her mom passes away prior to selling the property? And I said, well, that POA is null and void, right? Because the mom has passed away. So what they're thinking is since the daughter is the substitute beneficiary, they're thinking of transferring the property to her now. So she's going to become the primary beneficiary, right? So if they do that, is that considered a sale? Because the daughter is the substitute beneficiary of the trust. How does that work in terms of the legalities and costs?
It's considered a donation. So because it's the daughter, there are two options in this one. And the one that your client is telling you, it is doable. So the mother can acquire the 100% of the trust rights with the death certificate from her husband. Okay. Once she can do that in the same deed, in the same document, she can then donate those trust rights to her daughter. So, the cost will be the 50% of the transfer tax on the deceased husband onto her, and then the 100% onto the daughter. But this is a solution. I will ask my client, what do you want? Because I had a situation, and I had a situation like this before. I have the person, one of the beneficiaries, one of the main beneficiaries dying, the other person being very ill and sick, and the second beneficiary is the two children, right? So I asked the person who's still alive, what is your purpose? What do you want to do? He said, most likely my children will want to sell the property when I die. I said, and don't do anything. Just wait for you to die. It sounds very, very I said, but just if you want to do that, just wait for you to die, because you don't have then to pay that 50% onto you and then the 100% onto you. You will save money. So because if you once you die, your beneficiary substitutes are your two children, right? So I said, they will acquire the property. They will have to pay the 100% the transfer tax. Mm-hmm. But if you put it first on your name, you will pay 50% to you. And then when you die, they will also have to pay 100%. Mm-hmm. So they say it's that 50%. So in your case, for your client, I would recommend that to tell them that. I said, listen, I think I like that from my culture. That is not I don't like that from my culture, but I like that from foreigners' culture. Like in other cultures, it's very easy to talk about death. In Mexico, in our Mexican culture, if we talk about death, we're calling death, and in other countries, I tell my American clients or my Canadian clients, and they say, oh, okay. Oh yeah, that's perfect. So I'll just wait, I'll wait for them to die. Then I'll do that. I said, okay. Yep. That's, you will save money by doing that.
Yeah. I mean, talking about, someone passing away, it's a tough conversation, but you're just being real and you're just explaining everything the way it is and the best solution for them. And
I think we're all gonna die, sure, guys. And in this case, the thing with your client, Taniel, I think what they want is to sell. They're not urgently to sell. I will just wait, or sometimes I have had that clients too, that they said, I need the money because I need that to pay for my mother's care. Okay. Like, for example, I have it in a care home, so I need the money so that's when I do the first option, which is transfer the property to your mother and then make the donation to yourself. So you will spend some money there, but you can then sell the property just, it will be more secure, I would say.
Got it. So would it make sense in the purchase sale agreement if for the mother to sign the purchase sale agreement, but also put the daughter in there as well? So in the event the mom were to pass away, through the process of the closing, the daughter has already agreed to sell and it'll just go by smoother instead of having to do a new contract and stop everything.
Yes. Or you can just put it in the contract that if one of the parties die, the beneficiaries of the survivor, the heirs of that party, they have to complete the contract. Okay.
Yeah. Something you mentioned earlier, Orlando, closing coordinator. That is what you do. Could you explain? Because that's not very common throughout Mexico. I know in Banderas Bay, Puerto Vallarta, we have closing coordinators. So could you help our listeners and our viewers understand what that is?
Yes. So a figure doesn't really exist in other parts of Mexico, but like in the coastal or where the restricted zone is. Our job is basically we put everything together. In Mexico, notaries, and that's where I'd like to explain so people will understand why we are here. In Mexico, the only persons authorized to sign a transfer of property according to our civil law, every time you transfer property, it must be contained in what we call a deed, a public deed or escritura pública, right? The only persons authorized to do that are notaries, public notaries, which in the US or Canada, public notaries are, not like lawyers. Lawyers are the ones that do that. So in Mexico, in the legal ladder, notaries are here and we are below notaries in the legal ladder. Okay. But because a lot of times at the notaries, they don't have English speaking staff or people who will have the time to explain lawyers, like the clients that. So that's why we exist, explain them what are they going to sign, like everything that they need to know instead of just, showing up to a notary signing paperwork. Some of my clients, they said, they just took me to the notary, I signed, I don't know what I said.
Yeah.
That's what you need to know, to explain to you why you were signed.
Sure. Well, because the deed is all in Spanish, right?
Yeah, and the deed is in Spanish, or most of the documents are in Spanish. Everything is in some of the forms from the banks or lately, they have in both languages, but even like that, it is a legal paperwork. Sometimes some people are not even used to legal paperwork back home. So when they come in and they see all this bunch of legal paperwork, even if it is in English, they don't understand what it is. So we have to explain to them what are they signing, and I love when people ask questions. I love it because some lawyers don't like it in our culture, in Mexican culture again. You live here long enough. If you ask somebody something, people will say, Mexicans, we will react like, why? You don't trust me? Why are you asking me so many questions? But versus in your culture, you ask questions and it's very normal. So yeah. I get accustomed to that. To me, it's not a problem. And to my staff, I always tell them that. My cohort says that, guys, they're asking a question. There's nothing, yeah, but ask the question. Do you know the answer? Ask them, answer the question. That's very simple. They're just asking a question. They want to know. It's not that they don't like you or they don't trust you. It's just they're asking a question. They just met you a month ago. Of course they don't trust you because they don't know.
Your retirement in Mexico starts right here, and we're excited to be part of your journey. Every episode, we bring you the magic of Mexico, insider tips, and expert advice to help you take that next big step with confidence. Don't forget to subscribe and leave a rating and review on Apple Podcasts. It helps others like you discover the endless possibilities waiting south of the border. Got a topic you'd like for us to cover? We'd love to hear from you. Send your suggestions to info@tanielchemsin.com. And remember, a life well lived isn't left to chance. It's created with intention. See you next time.